Hello, and welcome to this bonus episode of the WorkWise for Screen podcast. It's part of a growing collection of practical resources and guidance designed for professionals in the screen industries, supported by the BFI awarding National Lottery funding.
Through these podcasts, live events, and our online community, we help our screen sector better look after all the people their businesses depend on and stay on safe, legal ground. Our guests share practical ways to improve working conditions and well-being across the industry.
I'm Tasita Small, founder of the Small HR Company, supporting HR in the entertainment industry.
And I'm Keith Arrowsmith, a creative industries solicitor and programme director for WorkWise for Screen.
This episode is a highlight from our live Belfast event, moderated by Brian Henry Martin. He was joined by Marcus Ryder, CEO of the film and TV charity, Mairead Regan, the HR consultant, Leanne Murphy, Employment and Equality Solicitor at Rosemary Connolly Solicitors, and Michelle Walsh, Head of Production at Stellify Media. Let's set the stage for today's episode, all about ways to legally protect your business.
We'll hear from Leanne Murphy, who shares her experience of investing in proper HR structures early on to prevent costly legal disputes, and the main differences between employees and freelancers with a Northern Ireland focus.
There are so many free resources available. In Northern Ireland, we're very fortunate in that regard. And certainly for small to medium-sized companies who don't necessarily have the financial ability to invest internally in HR departments or HR offers, it's very important that they utilise the resources that are available to them. In particular, with regards to employment law, the Labour Relations Agency is an invaluable resource toolkit that they have. This is it's an online service that all companies, all employers can register for, and they have a full suite of HR policies that you can tailor to your own individual needs. They're excellent. They're very good at working alongside different companies to ensure that they're getting the right value out of the resources that they have available. They're a publicly funded body. So, again, a free resource, but, your tax is paying for it, so you may as well utilise it. And again, they help with drafting contracts of employment, the statutory procedures that you have to have in place in Northern Ireland, such as the disciplinary procedures, the grievance procedures. Those are the two main procedures, at the very least, from an employment law perspective, that all companies must have, and that's a legal requirement. But certainly it is recommended, and I would recommend it, and I'm sure anybody who works in HR would recommend that, no matter the size of the company, that you do have a full suite of HR documents available. So that's one excellent resource. Certainly from the sounds of today and everything that we have been hearing, and my own research in relation to the WorkWise for Screen initiative, that's going to be a very useful resource. So again, fully engage with that. There are other resources, NI Business Info. They again have a full suite of policies. They're not as tailored, but again, if you do have somebody who specialises in HR within the business or is going to take on that role, there's useful template letters and things like that you would, or job descriptions, those types of things. There are small companies. There are a number of small companies that will provide HR advice and assistance to companies for sometimes an annual fee, a monthly fee, depending on how many employees you have. It would depend on how costly that is. They're a great resource, because that you have an expert taking care of your HR needs. I can't impress enough how important it is to invest in that. And I fully appreciate, certainly in my practice, we would deal mostly with small to medium-sized businesses. So, I fully appreciate there are a lot of financial obligations and difficulties when it comes to running a business. I run, a small to medium-sized business myself. It's something that sometimes is pushed to aside in terms of, where the money is going to be spent. But if you can invest in getting those policies and practices in place initially and getting them right, it can potentially go a long way to save the company if something does happen, because legal issues, legal cases, particularly in our employment tribunal here in Northern Ireland, are extremely costly. And it's not like England and Wales, whereby if somebody brings a claim against your company, and even if you were successful in defending that claim in the employment tribunal, you are still responsible for paying your own legal fees. So it's not, the costs aren't awarded as they would be in the civil courts, for example. So that's potentially extremely costly for an employer. So it's best to try and avoid that if at all possible from the outset.
Yeah, very important to do that. Now, legally, can you explain to us what is the difference between a freelance employee or a worker? Give us a sense of what the difference is there.
Well, that's a particular question. I have to say that most employment solicitors hate to see coming. It's the reason being that employment status is very fluid, and particularly in your industry. You know, somebody could start out as a genuine freelancer and then become a worker or an employee over time, and that often happens. Or there can be mixed communication in relation to what the particular employment status is. So it is a difficult one, and there's no one size fits all. I think it's important to make that clear. It's individual circumstances at the time, but in general, I suppose a broad understanding. Freelancer is another word for a self-employed contractor, essentially. So this is somebody who provide services to your company, and generally they would provide services to more than one company. They're not under your strict control, so to speak. They are free to accept work, they negotiate terms with you, and then they enter into generally a contract for services. They don't have the employment rights that an employee or a worker even would have. They're responsible, obviously, for paying their own tax and national insurance, filing their own self-assessments, things like that. But in terms of employment status, the main difference is the control that the employer or the company, essentially in this situation, would have over them. They are free to substitute others to get help in respect of the services that they're providing to the company. They generally supply their own equipment, things like that. An employee obviously would be the direct opposite of that. Then employee, you know, it's the easiest one to understand. They are employed under an employment contract. They have a full range of employment rights, and they are under the strict control and direction of an employer in that they direct their hours of work, the rate of pay, etc. But with that, then obviously they have job security. They have, particularly I suppose in this industry, the rights that they have and things like that. So that would be the main difference in those two. And then a worker is generally agency workers or people that provide services under, and there's no legal definition of this, but it would be a 0-hour contract essentially, in that they're free to accept work, but they don't have to if it's not suitable to them. But they do have employment rights, less than what an employee would have. But if they worked, for example, over a period of time and they did provide a certain number of hours, then they may well be entitled to holiday pay, annual leave. They have rights in respect of rest breaks, minimum wage payments, those types of things. So again, it's very important from the outset of an employment relationship of any nature to be clear as to what both parties think that is to look like, what both parties want, the services that they require, and to set out a written contract, whether that's a contract for services or an employment contract.
Well, look, we've heard today about the importance of being able to raise issues in the workplace. So, I mean, talk to us about that. How important is it to have clear, procedures on policy so that staff feel that they can raise issues?
It's extremely important, and I can't stress that enough. I would say 90% of people that come to seek advice from ourselves, certainly it could have been avoided if they had the clear policies and procedures in place from the outset. and they adhered to those and invested in the proper training. I suppose going back to the first answer with regards to the Labour Relations Agency and those resources that are available, they also do provide training. There's seminars. It doesn't have to, it can be online, and most of them are now online. They have training centres in Belfast and in Derry. They have the Equality Commission provides equality training. It's utilising those things, but it's very important to have them in place. It's very important that companies are reviewing those. And I always recommend on an annual basis, because things change over time. The needs of the company changes over time. The people working for the company changes over time. The needs of people, the things that are more important. So, since COVID, flexible working arrangements, hybrid working arrangements. Prior to COVID, there was very few companies that would ever have had a hybrid working policy in place. It just wasn't, it was something that most employers really tried to stay away from. But it's so important to have those policies in place now. With regards to statutory procedures in Northern Ireland, as I said, the main ones are the disciplinary policies, grievance policies, having your contractual entitlements set out, and employers are required legally to provide all employees with written statement of main terms of employment within 2 months of them beginning employment. Now, having said that, as I say, in my industry, I'm well aware that unfortunately that's not always the case. But even if you're after, even if you're sitting here today and you think, oh, well, I haven't done that, if you're well after the 2 months, it's worthwhile contacting the LRA and getting those things put in place. It protects the company and the employees. It's about investing in the people that are working for you, within your industry, because without them, then there is no industry. So you need them to feel secure within their working environment. And you also need to be aware of what your duty of care is towards them and what the potential legal liabilities are if you fail in that duty of care. So it's extremely important.
Extremely important. Now, there are some upcoming changes in the new Employment Rights Act. So what is important for us to know about those changes?
Well, I suppose the first thing to be aware of, and I assume most of you are already aware, is employment law in the UK is a devolved issue. So Northern Ireland is its own jurisdiction for employment law, and then England and Wales, and then Scotland is an entirely separate jurisdiction altogether. So that complicates things. It certainly complicates things for people within your industry, where, maybe if you work in productions in Northern Ireland and in England and Wales, you do have to be aware of the different employment legislation that is in place across the UK. The important thing is where the contract is performed. So if you're a company based in England and Wales, but you are undertaking a production here in Northern Ireland, then any of the employees who work for you are subject to the laws of Northern Ireland, and their employment rights come from here. So you have to be aware of those differences. So the employment rights bill that is being proposed by the Labour government in England and Wales, that's not coming into effect here in Northern Ireland. So there is a lot of talk about this in terms of, and it's going to be a massive overhaul of employment law across the water. And it's scary for a lot of employers, certainly, because, there's a lot of these big headline statements being put out in terms of these day one rights that our employees are going to get. But it's important to note that that's not intended, and it won't be coming into effect in Northern Ireland anytime soon. There was a consultation last year, the Good Jobs Employment Rights Bill in Northern Ireland, and I was involved in that from a stakeholder's perspective, from an employment solicitor's perspective, in terms of reforming the employment legislation here. In all honesty, the employment legislation in Northern Ireland has not been it's not been overhauled in well over a decade, maybe longer. It could be 20 years. In all honesty, a lot of the legislation is extremely outdated, and it does need a massive overhaul. But most of what is being suggested for Northern Ireland is really only to bring it up to speed as to what England and Wales is currently at. We're not going over and above anything, unfortunately, and that just seems to be the way things happen here. We're always a little bit behind. I suppose with regard to the film and TV industry, there is proposals and there certainly were questions within the consultation regarding 0-hour contracts. So again, for workers, people who provide work for your companies and things like that. In Northern Ireland at the minute, there is an entitlement for companies to still have exclusivity clauses within a 0-hour contract, meaning that somebody who provides casual work for the company can be prevented from working elsewhere, which is inherently unfair. So there is discussion of that being changed, and I think that will happen. The consultation closed last September, and the Department for the Economy had intended to produce the draft legislation in March this month, 2025, but as of yet that hasn't been published. So we don't know what they're proposing just yet. It won't come into effect regardless until, I would say, early 2026. But things are changing, and it's important to keep an eye on that and to understand fully what your obligations are in relation to that. So certainly keep an eye, keep engaging in the relevant resources available, because they will update and provide all of that information. And, if needed, seek legal advice, and, you will hopefully, be better protected then.
Well, that's brilliant. Now, Leanne, just finally on WorkWise for Screen, you've cast your legal eye over it. What's your kind of thoughts and why people should sign up for it?
No, I think it's an excellent resource. Certainly, as I say, these resources are so critical for small to medium businesses. Certainly engage with it. Why not? I think it would be useful if it had. If it did, as employment law is an evolved matter, if it did break it down to Northern Ireland specific, England and Wales specific, Scotland, those types of things, because they're, unfortunately, with a lot of small to medium companies, what they'll do is they'll Google something in relation to employment law. When does somebody have unfair dismissal rights? And if you Google that, it'll come back, UK, it'll come back and say 2 years, but that's not the case in Northern Ireland, it's 1 year. So you have to be aware of those things. So it's very rare that there would be a resource available that does set out the differences in the different jurisdictions within the UK. And certainly, I think if that is what's intended, which, I think would certainly be recommended, that would be an invaluable resource for companies who work across the UK.
It's great to hear from Leanne about how even the smallest project can sometimes cross borders, and we have to keep in mind the rules and regulations that might apply.
Definitely, when looking at something as simple as an employment contract and how the differences are between England and Northern Ireland, it might not be front of mind because we're so close and you wouldn't necessarily consider it to be an international space. But there are differences that are very, very important. And, we heard there about not doing that and how that can kind of turn around and bite you. But putting processes in place, in pre-prep even, and making sure everybody is understanding of what the contracts say, super important,
I think it's a really valuable point that if you have standard documents, standard policies, standard procedures, you've then got to check that your standard processes work for each of your projects. Because the moment that you cross a boundary or the moment that you bring in a team from Northern Ireland, it's going to be the Northern Ireland rules that you're going to have to make sure work for your particular project. She says 90% of issues could have been avoided with the right processes and paperwork in place at the beginning. And I thought that really does hit it home. It's this sense of a little bit of time and energy at the beginning can save lots and lots of heartache later on.
Which is why it's so great that WorkWise has these resources and can help in that space. Such a high percentage of where, maybe a few hours worth of reading, a few hours of consultation with the solicitor set you up for success along the whole of your project.
And it's a really delicate matter because you don't want to have contracts that are always 100 pages long. But on the other hand, you want to find ways of explaining what can be quite complicated structures or quite complicated systems in ways that people can understand and therefore abide by.
Agreed.
Thanks for listening to the WorkWise for Screen podcast, supported by the BFI awarding National Lottery funding.
Our online platform provides lots of easy to understand information and invites to our events. Visit our website at workwiseforscreen.org.uk and register for the latest updates.
Please follow us on social media and join in this crucial conversation.
And contact us with suggestions for future episodes or if you can support the programme in any other way.